Hey guys, today I got Alan Oaf and Cody Taylor, and we want to talk about the best interest standard. And today, unfortunately, we got some bad news. Cody Taylor is going to tell us a little bit about what happened to him in Comal County. For those of y'all that don't know where Comal County is, it's roughly New Braunfels, Texas, which is just north of San Antonio, Texas. So let's talk about best interest, guys. We don't have a script. We're just kind of shooting from the hip. Cody, you want to tell us what happened this week?
Yeah, so thanks for having me. So we'll start off with on January 5th, after a incident on December 31st, where officers came to our place and allowed me or kind of advised me the best thing to do would go to keep my daughter safe somewhere outside of the house if the mother was going to remain in the house. Just because us being together may lead to problematic. Child doesn't need to be involved. Our child's 1 year old. Our daughter is. So that's what I did. We went and saw some family, got away for a little bit.
So wait. The cops came to your house, but for what?
So on December 31st, that was our daughter's birthday. Mom had the night with her at her parents' house and family. And then I was allowed to have her at 2:30 that afternoon to have some lunch and some time with her. And then we originally had stated we're going to go back. She was going to go back to mom that evening. I apologize. Mom was going to come over here and stay the night. At that time, we were being decently cordial. But whenever I was leaving from picking our daughter up, I had found a tracking device in the bag. And so she had been tracking me for some time. We had found another tracking device as well.
But so there's no court orders, right? Y'all are just fresh breakup. It's a fresh breakup, pretty much.
Christmas Day. Merry Christmas. So yes, we broke up on Christmas, decided to go separate ways. A couple of days later, it didn't kind of go as planned with with the SUV that was in my name and not in hers, and just kind of the threats that went on from there. So we fast forward to December 31st. We had a agreement in, but no orders. We had 0 orders. We were doing everything kind of above board for the moment. So that evening, whenever I texted her and said, hey, we also met with CPS. CPS is now involved in this case due to a reporting of assault family violence, her against me. So CPS,
wait. So mom assaulted you and CPS got involved. Is that correct?
That's correct. After I made the report of assault, deputies with the sheriff's department, it's their policy, the mandatory reported to CPS because the child was involved. So they followed the policy to the T. So CPS met us on December 31st while we were having some lunch. We were done. We met, saw no issues with the child. Child's not being abused. Child's doing great, smiling, laughing, carrying on. But CPS was notified of the images and what had happened, explained a little bit of what was going on. And his only thing, now he didn't say, hey, I need you to run away with the child. Obviously, he didn't say that. He didn't say that he was putting in a protective order. He said he was going to bring all this information to supervisors and kind of complete his investigation and see where it went. But he did advise.
Police worker?
This was the investigator, yes.
Okay.
So he did advise. He said, I would keep my daughter, I would keep her safe, whatever that may be. I would keep her safe. And then I would limit as much contact around mom as possible, since y'all cannot be in the same area when y'all are disagreeing. Seems like it leads to something physical. I said, that's fine. So,
but she assaulted you and you reported it.
That's correct.
And I would say the same thing, because I've been assaulted several times by my ex. I call law enforcement. Law enforcement usually doesn't want to help. And that's in my case, but go on.
Yeah, so he took the report. He didn't do anything other than grab initial images and statements. Assault happened on December 6th, reported it the 29th, tussled with it internally. I don't ever wanted to have to go through that, but it just seemed like the behaviors of mom kept becoming more threatening, as far as taking the child away and using advantages that she may have in court. And it just got to be where it was more vocal at home. And I just saw that there was an attempt that something may come up. So then 2 days after having the report, that's when the incident in the driveway happened. So when we came home, I sent her a text and I said, hey, I'm not going to bring her to you. We're going to finish out her birthday. You had her last night. I'm going to have her tonight. We'll see you tomorrow. We're going home. We have a doorbell camera. She can clearly see when I'm home, and we have a automatic lock, so she can clearly see when we enter the house. So it wouldn't have been like we just went in the hotel, we ran away, did any of that. She clearly. But
there's no court orders. You're totally protected to do that. You're protecting your daughter from possible family violence. Had she called law enforcement and said that you abused her, do you think there would have been just a report taken?
No, I truly believe that if she had the images that I did and the story that I did of what transpired, I would be in handcuffs, if not already still in jail.
And I again, I've been treated that way.
I'm curious. Like you say images, like is that like a video or?
So she gaslit me to the point where it got to the point where both of our voices were elevated and curse words were being said, no threats or anything like that. But then she ended her video. I didn't know she was recording. She had tucked it away to try to get all this on film. And
my ex did the same thing. She recorded a conversation that turned into an argument, and then she used it in court. So it's a tactic, right?
It's a tactic. So let's say when the recording of hers stopped, we separated. Our daughter was awake. She wasn't screaming or crying. I went to change her diaper on the floor, and no baby always likes her diaper being changed. So she was having some emotion. Our daughter was in the kitchen. Our mother was in the kitchen getting a drink, ran out of the drink, was headed to the garage. She was a good 20 plus feet away 15 to 20 feet away from us. So then whenever I laid her daughter down and was doing all the changing, that's when she felt, I have my opportunity to go get her from you. So whenever I got done and I picked her up, she tried to wrestle her away from me. And whenever that didn't work, she dug her nails, I'm talking about, into my thigh, broke skin. A few hours later, it was already bruised, and up to like 2, 3, 4 days later, it was massively bruised.
Is that assault with bodily injury?
That's assault with bodily injury. That's intent for harm.
Oh,
so
okay.
I got away from her, and instead of calling the police, I called her parents. I tried to de-escalate it by not getting police involved, because I felt like the minute that they show up, there's a possibility that CPS takes the child.
Wait a minute. Did you show police the broken skin and all that?
Yeah. So I took images immediately after, and I sent them to her parents after having a conversation with them about trying to de-escalate the situation. They didn't want any part of it, but I sent them an image. I sent them a picture of it. And then whenever I gave my report, I gave an image of right after, a couple hours after, that evening, the next day, 2 days later, and then up to about a week after, and they were just increasingly getting worse.
Okay, so there was no physical contact with the child.
None. No. I kept our daughter away from her aggressive and obviously assaultive. What she was. Did
you have your daughter in your hands when she was scratching you?
Yes, when she couldn't take her from me. Like, she came over, daughter was in my arms, and when she came over, like, hey, we're not doing this. And then she reached to try to take her from her. It didn't work. I'm trying to get my phone to start recording, because I wish I would have been recording before.
Right.
But I didn't have any clue this was about to happen. And she just dug nails into my thigh.
Yeah, my ex did the same. I was holding Christopher, and she came in and she started pulling and tugging on Christopher. And at that point, to me, when we're talking about best interest of the child, I think some people automatically assume mama bear, mama's going to protect her cubs and stuff. But, fathers have the same rights and duties for protection.
That's right. Yeah. So this is once again a situation that she wasn't winning, wasn't getting her way, didn't like how it was going. And this will be the second time she resulted to a physical assault. So that's the reason why I called her parents instead of the police, and then came to my senses after, multiple discussions after that. And we finally separated. It's like, this is getting worse, verbally threatening to always take the child, threatening to go to court, threatening to call my ex-wife to bring her into this situation. So I was like,
oh, that's another common tactic. Call your ex.
That's right. So I decided to report it. Who's going to know that it happened if you don't report it? Who's going to, have any actual legal remedy if you don't report it?
Well, hold on. But law enforcement didn't even care to do anything to her when you reported it. It just, or what?
Was there an arrest made or anything?
Say again?
Was there an arrest made?
Nope, not yet. It's sitting now with the criminal DA's office in Comal County.
Okay. So here's a strange dynamic that kind of comes up when you're talking about it. It's not really great for parents to go to court and go through that battle. On the other end of the spectrum, if parents have any legal knowledge, they know that parents can't kidnap their children.
Right. But attorneys can force the narrative.
So if your daughter's mom sees the child in your arms, she's going to feel like she's about to lose control. And the same thing goes if the daughter's in her arms. You say, well, she could go to China and I can't stop her.
Right.
And so it's a very limbo place to be, because you don't want to go to court, but you're also in that back of your mind, you're scared. You're thinking they could legally kidnap my child at any time, which is what happened to me.
Yeah. I mean, same thing with me. I mean, we had an argument, and after Hurricane Harvey, I had to get the FBI involved to locate my child, and I had court orders. But Cody doesn't have court orders. Anyway, so y'all have some sort of verbal disagreement. The child is not physically hurt, other than two grown adults arguing. One scratches you, breaks skin. Okay, but before the best interest can be applied, there has to be a welfare issue with the child.
Right.
And I get it, but the family dynamic is so great. People have arguments in their house all the time. Doesn't necessarily mean that there's a welfare issue for the child. Would you agree, Alan?
It's a kind of a gray area. So CPS has removed children due to domestic violence when there was no child abuse.
Yeah, let me move forward through the December 31st. So December 31st comes back. I come back to the house. She knows this. She decides to pull up directly in front of me, block me in. She comes to the window, trying to get into the vehicle, tries to get in the door. I ask her where my vehicle is that she's now had for 3 days. She tells me, you can go find it. I asked if it was damaged, and she said yes. I mean, it's all a joke to her. She's smiling about this. So I found a window. She stepped back from the truck a couple of steps. And so I tried to leave. And when I tried to leave, she ran to get in front of the truck, which I stopped. I didn't hit her or run over her. But the police showed up. I called them, but she had been on her phone previously. So the assumption was that she called them first, or called somebody and they called the police. But the police got there, and typically what happens with the police, they talk to the person who called first. You're the complainant. Well, they didn't talk to me, so they went to her. So that was the assumption. But when they got her story, she said, I attempted to run her over. I'm supposed to give the child back. Again, no court orders. They can't do anything unless the child's in harm or danger. They came to talk to me, and we have the Ring camera, and the Ring camera substantiated that she was not telling the truth. Okay, so nothing happened to her.
Okay, so she's already assaulted you. She's broke skin in front of the child. She's trying to impede as you're trying to leave your own residence. And she lived there, or she doesn't, or
she lives there. We both do.
Okay,
but she had been at her parents' house. She had already taken some things and been over at her parents' house several nights.
So when y'all separated, she left the house.
Yeah, after December 25th, she decided that she was going to spend some nights over there. She spent a couple nights here, and then she started staying nights there.
But y'all already talking about a divorce or breaking up?
Just a separation and what we were going to do. And we had seemingly been responsive to each other, but then it turned negative after this. So inside of her vehicle, she had her 11-year-old son and his girlfriend. So they also witnessed this go down. Police show up. She could have left at any time after the officer said that I am free to take our daughter wherever I please. There's no court order. She's not in danger. I'm in possession, so they're not going to take her from me. But she waited around until I packed the bag, because the officer said, you stay here, right? It's not the safest place because we can't keep her out of it. What it's going to do is it's going to create more problems. We're just going to be back. And if you leave your daughter and she picks her up, you can't stop her from leaving. So if you stay here, there's potential safety issues. So we left. We were gone. On January 2nd, she filed a pro se emergency ex parte to bring her back. No allegations of abuse, no allegations of assault against mom, no allegations of harm or abuse to the child. All she stated is that I ran off and it's impactful psychologically to the child to be away from mom.
Wait. But there's no court orders? So she did an ex parte with no court orders?
She did a request for ex parte with no court orders.
Pro se.
Pro se. Yeah.
And what happened?
The judge didn't grant anything when she filed on the 2nd, but her attorney came in on the 5th and got them immediately. We returned on the 4th. Nobody was at the house, so we returned. And I was served with a writ of attachment to take the child.
Based on what? What was the welfare issue?
The welfare is that she was taken from her mother. That was it.
Don't we have parental rights? Don't we have parental rights in Texas? I mean, is a father a parent? Does he have parental rights and duties? So so now we're just going to take the child away from you based on so there was no evidentiary hearing to limit your liberty interest to your child.
Not prior to the writ. No, it was just her affidavit and text message saying that basically what she claimed is I was holding the child hostage against her will. And I was using that as a tactic to coerce the mom to agree to what I was doing to bring her back.
So the 1-year-old made that claim?
Yeah, as she was eating mac and cheese, I guess.
Oh.
Yeah. Yeah, I guess she sent something text message wise at 1. I don't know. But
Alan,
that was the claim.
Alan, what do you think of that?
It sounds like she's almost alleging that you kidnapped the child when there was no order.
That is exactly what she kidnapped. Yeah.
But parents don't kidnap their children when there are no orders, which is why everyone feels so threatened when there are no orders.
That is correct. You hit the head on the nail, is that she felt threatened that I was when was I going to come back? Right. Even though we were in communication, she had FaceTime, she got pictures, we were still talking.
She retained a lawyer, right?
If someone is a risk to flee, or if someone's just paranoid, sometimes you do need those orders to give a sense of security to the co-parenting relationship.
Okay, Cody, do you have a criminal record?
Nope.
No criminal record?
Never been arrested for a felony or a misdemeanor in my life. Ever.
So we're just taking your kid based on what she believes, right? No evidence, no discovery, no nothing. Just we're going to do an ex parte writ.
That's what she did based off text messages, and the only thing the text messages stated is that I asked for something to be pinned to pad so that we were both protected, so that we had some sort of an agreement. Basically, you can use that as a Rule 11 and actually file that and have something of a standard, right? But she was already moving with an attorney with what she wanted to do, and that was the only claim. She claimed also that I'd taken the keys from all 3 vehicles that we have here, which one's a work truck and the other 2 are in my name. It's my personal gray truck, and then we had a family SUV. But when she was leaving after we had separated on the 27th, she started threatening about going to court. You'll never see her. I'll take you for everything you've got. I'm going to call your ex-wife. She's going to be a part of this. And that's when I asked for the keys. Like, you're not going to take a depreciating asset that's going to be on my record and just go freewheeling around and maybe damage it.
Now, is that 100% your property, or how is that?
It's in my name.
Oh, so so where it says in the Constitution that, life, liberty, and property shall not be infringed unless there's due process. So there's no due process here, and they're taking things from you?
Yeah, so at this point, she got the keys back. She accepted responsibility within 24 hours. She said, I take full responsibility if something happens to the vehicle. So she was able to get to work where she needed to go. And then on the 31st, 3 days later, she shows up in a new vehicle, not my vehicle. So we had to ask the officer to locate it. So fast forward after January 5th and the constables come to get our daughter.
Wait. How traumatic was that when constables came over? to take
no idea who was going to be there. They tried to play this off in court as I didn't answer the door right away, which I don't answer when somebody rings the doorbell or knocks. I look on my camera, as most people do. So it took me a minute to answer, and then whenever they told me what they were there for, I mean it's shocking, but what's the fight, right? So I didn't fight it, but it's just the point of I just had her for 5 days. We were perfectly fine. She was asleep in our bed. She's now getting woke up, and putting in a car seat. And then I'm left here trying to figure out the pieces from there. So it's traumatic in the sense that why? We're back home. Emotions have died to an extent. We can work this out.
The baby was born in that household, right? I mean,
so the baby was not born in the household. However, we'd been here since July, so it's the last 6 months. This is her home.
Okay, all right.
But where she went was her parents, and that's where she was born. So at the grandparents' house is, if you will, to say as close to home as it gets. However, waking her up, putting her in a car seat, driving off. I mean, that. You were with dad, now you're with mom, now you're not with dad for an extended period of time. So, and
you're going to grandma or grandpa's house or somebody's house, right?
You have no idea what's kind of going on. And that was the thing to Alan's, what Alan continues to say is there's no child that can be held hostage by the parents. She's 1 year old. She's hostage to what we do daily. If we go to the store, you're coming. If we go to a ball game, you're coming. We go to practice. We decide to take one of the kids to the doctor and it's not for her. You're coming. You're always with somebody and they don't have a say in where they're going to go at 1 year old. So it wasn't hostage the week before Christmas when we went to see my dad for 4 days without mom. We're okay with that. But now it's hostage situation.
Okay. So
let's get to court.
So let's get into the court. Yeah.
Yep. So we're in the court. We filed a motion to vacate because her original affidavit and supporting evidence, no imminent danger, no harm, no abuse, nothing to the child, only has to do between me and mom. She doesn't put anything about abuse to her or assault to her by me in her affidavit of supporting the TRO, the ex parte TRO. We get to court and we light it up with me being on the stand first, and it's just a constant beratement about my first daughter. I can't see her. I can't be around her. I'm very cut off. I'm only by phone. They tried to lay a foundation that I'm already a danger. That's what they tried to lay. Whether it worked or not, I'm not 100% sure. What it did move into is that once we got to offer evidence of 2 police officers, the one from the night at the driveway, he stated that she was not truthful and what she stated was not factual. And that he did tell me that I should seek somewhere safe that she can't just obviously be roaming inside of with me. And then the other officer who said that the criminal DA had an open pending assault family violence. And then CPS stating
Did law enforcement offer you any domestic violence resources, like any places you could go to take your daughter for a man?
No, they did not.
Some?
Say?
Can I offer you some?
Sure.
All right. I'm going to read something. So it's 105.0011, information regarding protective orders. At the time while a suit is pending, if the court believes on the basis of any information received by the court that a party to the suit or a member of the party's family or household may be a victim of family violence, the court shall inform that party of the party's right to apply for a protective order under Title IV. So what that's saying is that when the court finds out that family violence has occurred, the court needs to say, hey, we got a SAPster going on. You need to go file a protective order because family violence has occurred.
So, okay, but
did the judge ever inform you of your right to go file a protective order during the hearing?
Okay, but
I'm informing you of your right.
Okay. So I did ask for a protective order on my own, but the court never asked if I asked for or have filed for a protective order. Nor did they instruct me on what to do next if there was one, because it was alleged in my supporting affidavit that she had been physical, and we applied images with that affidavit.
So how come? Wait. And this is a problem that I have, right? Is how come our affidavits are often either misconstrued, misinterpreted, not taken seriously, right? But their affidavit, a woman's affidavit, and it doesn't necessarily have to be man versus woman, but you see it a lot with women. And in my case, my ex, she made a fraudulent affidavit. I mean, that's perjury. Perjury is against the law, whether a family court judge wants to acknowledge it or not. They don't get to rewrite what the legislature has legislated. They have already legislated. Perjury is a law. And for family courts to dismiss that and then take your property, take your children, and there's no admonishments to people making false affidavits, that's a problem in family court that needs to be addressed. And it doesn't need to come from the people, because the people have already legislated this when they elected their state reps and their state senators to legislate the relief from perjury and aggravated perjury. Right. And so now we have judges that don't give a squat what your affidavit says, but we're going to accept everything that their affidavit says. Come on. How is that equal under the law, under your 14th Amendment?
Well, and we've talked about this too during legislation. If you'll remember, at least the last two sessions, is that how easy it is for a party to get a restraining order and pull a child or keep that parent from the child. How easy it is. If you go back and you look at her affidavit was took a child hostage, which, to Alan's point, exactly, a parent can't take a child hostage when there's clearly no court orders anyway. And then the second part is that I took keys, but that again does not present an option of danger to the child when clearly there's resources available.
Well, wait a minute. She left the house.
She chose to leave the house voluntarily.
Did they even use the word hostage?
No, that's what I was trying to look up real quick, is what she actually used, because it's, hang on. Keep going, though. Her verbiage was against her will, I believe.
Against her will? Yeah, they said Christopher didn't want to go to his dad's house, and he was screaming. They say Christopher's autistic. They say Christopher, was being held against his will by dad. He didn't want to go. Christopher is 6 years old. And when you have a 1-year-old and they're saying that for the child,
that's
speculation, hearsay. I mean,
right. Offer of no proof.
There's no testimony by a 1-year-old.
Cody, you filed an application for protective order?
I did, and it was denied.
Oh, it was denied.
Let's talk about that. Did you have a full hearing?
I did not. No, it was just from the DA's office.
Wait. Did you ask for assistance with filing an application, or did you file an application?
I filed an application.
You filed an application, and did you get a court note, like a case number?
No.
Then you probably were asking for assistance.
What's the difference?
Okay.
Tell us the difference.
Yeah, explain that.
So they basically try to say, go to the DA and ask for a protective order. What they're saying is, go ask for assistance with help with filing one.
Okay.
But asking for help is not filing one.
Okay.
So the DA can file one for you, but they say, oh, no, you don't qualify. You've been denied. You've been denied assistance.
Okay.
But if you go down to the county clerk's office and you file your application, they'll timestamp it and it'll be a suit.
That's a good point, Alan. That's a very good point. I never thought of it.
A lot of people say, oh, no, the DA turned me away. They turned you away for assistance. But they didn't. Your application has not been filed.
Okay. The prosecutor reviewed the additional information, and she is denying your request for a protective order at this time.
The prosecutor is not a judge.
Okay.
That they denied your assistance. They denied their assistance to you.
I would say the same. I did the same. I didn't know that. But that's a good.
I've asked for assistance half a dozen times, and I've filed 2, and my dad has filed 1 application. So
I received.
Okay.
Well, hang on. From them, it says we received your application for a protective order. To qualify for a protective order, there are certain elements of family violence you must meet. So I will need you to explain exactly what happened when he or she physically harmed you. Here are the questions, which I answered all their questions with a timeline.
When she physically harmed you?
Yes.
So she broke skin, right? Did she break skin?
Yes.
What
and
document,
bruising.
When you answered the questions, what document were you answering the questions to?
It was just an email, copied and pasted in an email.
That's not an application filed with the clerk. That's not a suit filed with the clerk.
So you would need to. I wonder if they've got one online.
This whole
Texas
time,
law
I've been going back and forth about whether or not you're going to get assistance.
Yeah.
Okay.
Texas Law Help, right? I think they have a generic protective order.
Yeah.
That you can use. If not, I got several that they've used on me.
So I've learned a lot about protective orders. If you have evidence, you're not allowed to have one. First, the DA will say you don't qualify. Then if you actually do end up filing an application and filing it with the clerk, you'll still get denied. And here's why. Because when you have actual evidence, protective orders solve a custody case way too quickly. And it can't drag out for years. And so, protective orders is a top secret thing that they don't want anyone to know about.
Yeah. So what I filled out is it is protective order application. Comal County Criminal District Attorney's Office. Protective order is a civil lawsuit. There are two types of protective orders. So I put it in for family violence.
So the district attorney offers assistance, but they don't. They're not a judge, and they don't make determine. On Chapter 85, it says the judge will determine whether or not family violence has occurred, and if it has occurred, the protective order will be it'll be drafted. It'll be given. So Chapter 85 says the judge decides whether or not a protective order is given. The DA can offer assistance in filing one for you.
The scope of the Criminal District Attorney's Office representation is specifically limited to obtaining a family violence, stalking, sexual assault, human trafficking protective order under Chapter 85 of the Family Code or Chapter 7 of Rules of Civil Procedure. As part of this representation, an assistant district attorney will draft documents, address motions, appear in court, and other legal actions necessary.
You were applying for representation.
Okay, but why is it this hard for Cody to do that when they're giving away like prizes in Harris County? I mean, Harris County. I mean, look what they did.
They're only giving away when you don't have any evidence.
Okay, I like that.
When you don't have any evidence.
Yeah.
If you have evidence, you can't get a protective order.
I would agree to that because I had police reports. I had pictures in those police reports. I have an affidavit from the law enforcement agency, to authenticate the files that they gave me. Right? They're not redacted. They're straight from the police department, the police agency, and still, the DA in Harris County and the family court judges, they didn't want none of it. Especially, and that's kind of why I'm in the advocacy. It's because I don't want to say these women, but from my view, my perspective, as a heterosexual male, I've seen women use protective orders, to take everything you got, Cody.
Yeah, so we got down to that, and I just sent you the link for it, Alan, so you can click on that, pull it up. But we got to court. We had two officers sit on the stand, confirm exactly what was stated. One from the driveway incident of her not being truthful, no intent.
And so you got the transcripts of this? Not yet, obviously.
Not yet. We're working through it.
But you have an officer stating what? What did he say on the stand?
So the first officer that we put on there stated of the December 31st driveway is that when originally talking to mom alleged that I tried to run over her. I attempted to run over her. Once he saw the video that did not corroborate any part of her story.
Y'all played the video in the courtroom?
Yes.
Okay.
Yep. We played the video, and her attorney continued, like they always will, but she continued to say that, yep, you can see clearly he's trying to do this, whenever I stopped well before she ever got to the front of the truck. So the officer at that point in time realized what it was. Again, once he stated to her that there's no intent that I tried to do any of that, the child is not harmed in my possession, and child's going to remain in my possession until.
So there was no welfare issue because that officer obviously would have, probably taken the child.
Taken her.
Had he seen a welfare issue with you and that child, but there wasn't. Okay.
No.
So what did the second officer say? Or
the second officer testified to my report. He testified that he did see the images. He testified that they were time stamped, that they were concurrently after, the damage or bruising and cut was after the fact.
And the images you're talking about are the broken skin, correct?
Yes, they're on my leg, which mom and others testified that she had short nails, like she couldn't break skin because she had very short nails being a nurse. So you grab somebody hard enough, you'll break skin with any portion of a nail.
So she's a nurse and she's doing this.
Nurse, and she's doing this. Yeah, she's being the aggressor and being the assaulted person when she doesn't get her way. But he confirmed what he saw. I sent him 4 or 5 images over that day.
For them to limit, restrict, or terminate your liberty interest to protect your child, there's got to be due process.
Yeah.
Right? You got to have an evidentiary hearing. And if you have 2 officers and she's a nurse, did she report any of this, any of these issues to law enforcement other than, her attorney are mandatory reporters too. A judge is a mandatory reporter.
Well, the only difference on the mandatory reporter with a client is the confidentiality side of it.
Hey,
they would have to be acts of a criminal act that's been committed.
Well, she's having the child removed from you.
I know.
Is that a criminal act? What criminal act did you partake in for them to remove your child? So we talk about liberty interest, but if in criminal court, if I'm going to restrict your liberty, throw you in jail, there's certain things that we have to go through. We have constitutional safeguards, due process, before we can just throw Cody in jail. So I like to tell people too, with liberty interest, it's the same thing, right? Your liberty interest to parent your child, to protect your child. Cody here is trying to protect his child. He's doing everything that he can, calling law enforcement, getting law enforcement involved, getting them on the stand, producing images and Ring camera. Here he is trying to prove, and a judge is not treating him equally under the law. The 14th Amendment, huge due process issue, right? And now we're limiting, restricting. So they take your child. What else did they do in court?
So they took me from being able to have any access to her every day, which I've had up until January 5th. I've had access to her unless I was at work, obviously, but still had access. If I left work, I go get my daughter. If I'm not at work or mom's at work, I have her the entire time mom's at work. I have her overnight whenever I've left to go. I've had her kids overnight whenever we went hunting or anything else. So I've never been without my daughter unless it's warranted, being that it's mutually agreed upon.
Let me ask you, did they put more emphasis on her child and your child from your previous relationship than on your child you're talking about now?
Yes, it was probably the heaviest hitting portion of that was in the very portion to lay the foundation to the judge that I do not have access to my first child. And we all know you through the advocacy. You've been fighting. You've been in Austin trying to legislate bills and trying to protect your daughter, not only from
the issues with the other parent, but from the court system itself. So I think it's unfair. I think it's really chicken shit when these lawyers try to bring up your past. They did the same thing with my oldest daughter, trying to say that there was a protective order, which there was, right? But there was no family violence. I simply tried to take her cell phone away. But because there was issues, they tried to use that. And when that has nothing to do with your current child.
Nothing.
Right?
We have nothing involved with our daughter at this point. That even CPS stated on the stand that the child with either of the parent is not seen as in harmful situation. However, the situation with both parents together does not seem, if they get in a disagreement, there's a possibility that something happens between the parents.
So what's the significant impact of them taking your child from you?
Well, at this age, so I'm limited now to every Wednesday from the time I get off work, which that could be 4 o'clock, 3 o'clock, 5, 7, whatever, to 7:15 every week. And then first, third, and fifth from 6:30 in the morning when mom alleges she's going to work to 7:15 when she gets off. So I don't get the entirety of the time, but I get Saturday and Sunday from 6:30 to 7:15, so almost 12 hours.
So we all know where this goes because temporary orders become permanent. So, 3 years from now at trial, they'll say the child has been doing fine. We don't want to disrupt the child's schedule because that would not be in the best interest of the child to disrupt something. So once something is in place, it really is difficult to change it.
Okay, so while we're on that topic right now, Alan, you and I have read case law about termination of parental rights, and we've seen the I don't want to say preponderance of evidence, the standard of proof change from preponderance of evidence to clear and convincing when it's a third party, a parent versus non-parent, whether it's a significant other or a grandparent, that they must meet a clear and convincing burden of proof. And there's got to be, strict scrutiny. It's got to be narrowly tailored, but we don't see the standard of proof when we talk about parent versus parent constitutionally. We haven't seen that. And we really can't do anything because I don't think there's remedy when there's temporary orders. Was there any findings of facts or conclusions of law that they were able to give you?
So the findings, so let me finish this. They did also remove me from the house that I'm currently in now, which I pay for. I'm on the lien with mother. I've never said that I was going to be away from the house. I was forced to be away from the house, and they put a 300-yard injunction.
So they took your kid, and now they're removing you from your own house, your property that you bought.
Because she assaulted you.
After she assaulted you.
So that's the thing, is that while she was testifying, she claimed that this whole December 6th incident happened because I was holding our child, but I pinned her to the ground, and that's the only way she got out. However, she made no report to police, no timestamp that she sent pictures of bruising to her family or other. She made no assault claim or abuse claim in her pro se affidavit or affidavit of support with her attorney. And now, after my affidavit was in play to vacate the restraining order, and I alleged it, it's all in there. And I've made reports, and CPS has talked to her. Now we're talking about I abused her first. I assaulted her first.
And so that's another common tactic that you see, is that they're asking for certain relief and they don't meet the elements, and it's no longer embellishing. It is fabrication now. Now we are going to fabricate a domestic violence, a domestic violence issue within the household just to take over your house, Cody. She goes and stays with mom for a couple of weeks, gets together with mom, comes up with a plan, and now we're going to fabricate domestic violence, which was never reported. What happened when you try to report the domestic violence? What did they tell you?
Well, they had to get an officer, and I did report, and he took everything. He took the initial statement. He didn't give me any grief about it. He just told me what was going to happen because the child was there. So it wasn't deterring. Not yet. That's going to be in the report.
Yeah, get that for sure.
What was that question again?
Did you get body cam footage?
Oh, body cam footage.
Yeah, so we're gonna get that from my initial report because I didn't report it the day after. I reported it time after. It was like 15 or 20 days after.
But she could have done that as well, but she didn't. Is that correct?
She did not. She absolutely could have. Right. She could have went down and showed them the supposed bruise that from me pinning her down and
it's the same thing. Things. It's the same thing with my case. Like my ex never reported. George. No ambulance ride, no doctor's visits. She didn't report it 1 week, 2 weeks, 3 weeks, 6 months later, nothing. But when we get into family court, oh my gosh, she can't look at me. She starts crying the crocodile tears, and now she's starting to say that I chased her down the street with a weapon. No neighbors. She was running with the child in her arms. I was running down the street with her, chasing her with a weapon. But no neighbors called law enforcement.
Right.
She didn't call law enforcement.
Yep.
She didn't call the ambulance. She didn't tell no therapist. She didn't tell anything. But this whole fabrication of this incident pops up at final trial.
100%. And
that was fabricated. Right. And
that was the other thing is she's a nurse. I mean, George, you're ex-firefighter. I mean, how many times do you take your shirt off or take your jacket and pants off and realize where the heck did I get this from? What happened here? Where did this bruise come from? So she would come home with bruises. I mean, from either picking somebody up or somebody, going against her and she got a bruise from whatever, bumping into things. It happens. But it just so happened the picture that she showed was just a very faint bruise compared to what I produced to what was going on. But again, mine was in a report. And then we talk about 2 weeks later, now we're almost a month. We're talking about, for the first time, we're now talking about assault by Cody.
Okay, so look, check this out. In my case, and I don't want to go too much sidebar, but in my case, my ex presented a picture of a broken alarm pad in her as part of her exhibits, and it had blood on it. And I'm thinking, like, what is this, right? Yeah. Turns out, I found out during public information request that her ex-boyfriend and her had been fighting, and that she filed criminal trespass on him not to show up to her property because there was an incident at the house. I truly believe that picture of a broken, pad was from her boyfriend, but it was used in. I tried to get them to authenticate it. Where was the time, the place? Was there a report made? But the judges are going to do what the judges want to do. And that's right. Where the oppressive portion of this comes from. We're taking Cody's child away. We're taking Cody's property away, taking his cars away based on fabrications, not even embellishment. You can't even say it's my perspective and I believe this balloon is a lot bigger than what really happened. This is like fabricating a whole new set of domestic violence issues in order to obtain the advantageous results in family court. And that's a lot of the issues that we're seeing, and people are starting to speak up about it.
Well, I know Alan's heard this as well, and I know he's kind of been quiet taking it in, so I'm sure that brain's roaming. But at the end of the day, we've noticed you've sat in court, Alan's sat in court, we've all been through court. How many times do most people walk in court with actually any relevant things? They don't. They build a case inside of the court proceedings. Okay, but they start,
and that's where I say we need to know the rules for the attorneys, because the attorneys, one, need to investigate their clients' allegations, embellishments, right? So that they're not bringing cases in forms of harassment. So I believe, and this is just through my research and reading the Texas Lawyers Creed, the disciplinary rules of professional conduct, the Texas judicial canons, these lawyers that are advancing these claims that they haven't investigated, right? They have a duty to investigate their client. And these attorneys that are embellishing or fabricating in order to gain that advantageous result, those are the attorneys that pervert the judicial system we talk about.
Well, they lay the precedent of what are most judges, family law judges, are family law former attorneys.
Right.
They lay the precedent. What was allowed? What did I get away with? How could I loop this back in? Filed a pro se affidavit, filed for ex parte without having any case already filed. And then, couldn't get it on that Friday before. Now I wait for my attorney. Boom, my attorney walks in, writ of attachment, go get the child. But no alleging of any danger, imminent danger to harm. That's the other thing that really stands out is they don't do any due diligence to, okay, show me harm.
Hey, Cody, were you standing or sitting when she clawed you?
I was sitting in front of our couch on the floor.
All right, so I'm thinking about the crime scene.
You want me to show it to you?
Actually, kind of, yeah. So the fingernails, they would make a U shape, right?
Yeah.
Which direction was the U?
Going
outwards. Towards her.
Yeah.
Yeah. Well, back towards her. So on my outer thigh, when she reached down, they're back towards her.
So if you were standing up, hypothetically, it would be an upside down U.
If I was standing up and she grabbed me with her right hand, it was on the side, so it would be up and down, but the U would be on the outside towards my leg.
Okay. The reason why I ask is she said that you pinned her. If you pinned her, then
outside.
Outside. It would be the opposite way. Right.
Outside, not inside. Good point, Alan. You've been watching a lot of that. What is it? SVU crime scene.
Well, my daughter went through a lot of abuse, and since the police investigators wouldn't do their job, I had to basically prove how the injuries occurred.
And so that's another thing, right? We are supposed to be treated equally under the law. That's what everybody's been preaching. That's everyone wants to hold everyone accountable these days. And yet we're doing our due diligence as men, as fathers, as protectors to protect our children. We're doing what we've always been taught. If you get in trouble, call law enforcement, right? If you break your arm, call 911, ask for EMS, right? That's what has been ingrained in our brain since the third grade. But some of these parents are inciting violence. And because you're a certain gender, you get treated a certain way opposed to being a man. Right? And so realistically, we have this 14th Amendment that says, hey, we're all supposed to be treated equally under the law. We're reporting it. Alan, I know you've done your reporting. I've done my reporting. I got locked up for reporting. I got thrown in jail for criminally trespass while I'm there to pick up my child with a district court judge's signature to be there. Plus, I was never even trespassed, and they still threw me in. And a lot of these officers, what they're doing is they're throwing people in jail or they're writing their reports, right? So they don't have to deal with it. Let them go to family court and figure it out.
So here's my, yep.
Yeah, and no, so right. just to be real quick, and so while they don't want to deal with it on the criminal side, we're just going to pawn it off on the civil side and let them figure it out. So now, when people get frustrated, people get murked or unalived.
Yep.
Right? There's probably chances that they have called law enforcement for help and they're being denied, just like you're calling for help at the DA's office. Right? You're asking for assistance on a protective order and you're still being denied. How is that in the best interest of the child? How does that follow your duties or your responsibilities to protect your child? Like how? Well, I don't understand it. I really don't
either. And that's the thing. Whenever you sit here and you talk about findings, this is kind of where she's at. And I'm paraphrasing. This isn't verbatim. We'll get the transcripts. But both parents have made poor decisions with the other parent, meaning that we've stayed in the situations of arguing that led further than it should.
Who said that?
This is what the judge said. As she was kind of going down her list of what was going to happen, she would give kind of a reason behind it. Mother has been physical against father. but there wasn't a finding by the court of family violence. One officer testified a pending criminal case.
Say that again.
Mother had been physical.
What does physical mean?
Right. Wasn't able to have an interaction. I was told that my attorney will represent me. So didn't get a full one on that. Mother did bring her young son and girlfriend to the incident in the driveway, and they witnessed this behavior. That's not good parenting, is what she said. Both parents have chosen to stay as long as this relation has been questionable.
Wait a minute.
Right.
We are January 24th. This happened, you're saying early December. That's not even 2 months that y'all have, right? And I've seen relationships. I've been in relationships where we've been in more toxic for months, not maybe even years, right? I would say that y'all handled this really well for a month and a half that this all started.
Yeah.
You know,
father has a quick trigger with temper. This is how she started escalating the problem for me. Father has a quick trigger with his temper when not liking what things are. He seems to be very black and white, which would go with ADHD. Has no basis of relevance.
Well, the judge said that?
Yes.
So the judge is he's well versed in being able to say that you have ADHD. Do you have ADHD?
Well, a child custody evaluator 5 years ago stated that I did.
What test did you take for that?
Well, we had an MMPI, and then he did some cognitive, IQ and cognitive.
What did they say about your IQ? You're smart enough?
I'm smart enough. Yeah, smart enough.
Look, I'm not a rocket scientist, right?
But you ain't got to be a genius to be a parent.
Right. You don't have to be a genius that when someone breaks your skin, you call law enforcement. So how does this judge tell you that you have ADHD, you're high-tempered, when you're calling law enforcement? If you're high-tempered, SWAT, you would have hit the woman, and then it would be the other way around. But instead, Cody, who's tempered, calls law enforcement, calls them several times to get a woman from standing in the middle of his vehicle when he's trying to take off. You know, she's digging her fingers into his skin, and he's tempered.
Yep. Mother is more stable than father at this time. Stability.
What? I mean, what did law enforcement say?
At this point in time, her emotions were getting in the best of her, is what they kept saying. Yeah.
What? Repeat what you just said, Mom. What?
Mom is more stable at this time. Mom has more stability.
What stability? She ran out of her house. She went to her parents. She didn't try to have a civil discourse. Instead, she just went after you, scratched you, broke your skin, stood in front of your vehicle. But keep going. Yeah, Mom's more stable. Keep going. I'd like to hear more.
The routine has been altered due to living in her parents' house that she chose, that she voluntarily left for.
That's unstable. All right. So did you? Is that it, Cody? You got more?
No. She stated that the other primary reason was that she has 2 other children and they need to be back in the house and their routines matter.
That is not your problem, Cody. Does their dad pay child support? Okay, so that's his duties and responsibilities to his children. Why are they taking your property to fulfill another man's duties and responsibilities? He's the one paying child support. Now they're going to take your house, your property.
They're not even a party to the suit.
Nope.
Sorry, nope. George, let me ask you to do something. So this is a fairly typical case, I guess you could say. You know, the first time you hear it, you're like, man, that's bad, but it happens every day. How do we apply this new constitutional amendment in Texas to someone like Cody's case?
First of all, we're going to need to argue it. we're going to have to acknowledge that. Look, Justice Lerman, ex-Justice Eva Guzman, right? She was a Supreme Court justice. She stepped down from the Supreme Court of Texas to run for a political position, which she didn't get. So now she's an attorney for an appellate law firm. She's sending in amicus briefs, and she's sending in other appellate briefs for parents. And she's saying the same thing, that Justice Lerman has said that a lot of these judges don't know what the fit parent presumption is. And I think when you have judges making decisions like you hear from Cody, like a parent was more stable, when obviously, Cody, I've known Cody for years, right? And I've seen his temperament. I've seen how he advocates in Austin. He's always been professional. I know Cody is smart enough to be able to protect himself when he gets in this situation because of his previous situation and previous court hearings. He knows what the game consists of. So when this man is doing everything right, he's going to Austin to advocate for better laws for best interest of the child. He's going in there advocating that mental professionals don't lie, don't fabricate, make things up, right? We know there is an issue within these family courts, and it's going to be us to educate the public to start demanding that these judges understand what the Texas Constitution is and why it's there. It's to protect the people from our government officials, from our judges, from attorneys, from the state bar, from CPS, Health and Human Services.
Here's what it does in layman's terms. Instead of asking which parent is more stable, the question that needs to be asked is, has so much instability been introduced into this child's life that abuse and neglect has occurred? That's when a government can come in and
right. There's got to be a significant welfare issue. Parents arguing right now when you have a mom coming in and they're taking property away, right? When they're already saying, "Hey, Cody, and I'm going to get your ex-wife, and we're going to take you for everything you got."
So let's say there are two students. The judge's job is not to ask which student had the better grade. The judge's job is to find out, did either parent have a failing grade?
Well, why doesn't the judge report it if the child is
facetious, right? Okay.
No, yeah. No, you are. I get where you're going with that, right? Is that it's not a basis to even do any of that.
Right. Right.
So, and if you talk to a lot of these mental health professionals who that really don't gain anything but financially, they'll tell you ADHD is a big deal, when real psychologists, real LPCs, the people who do the studying and the research on it, they'll sit there and go, we function with a version of that every day. Every human has a version of it. It does not limit you or restrict you from being a quote unquote fit parent.
Right. They're a mandatory reporter. So call CPS, tell them.
What was that movie? I Am Sam?
Yeah.
Or Rain Man?
Rain Man's and Rain Man.
Right. And that's what they try to do with me, is try to make me unstable, try to make me, my pelvis was broken. I wasn't taking my meds. I'm in a danger to the child. I have a 2-story home and the child could fall from the stairs. I mean, they were bringing everything up, but everything. They were trying to allege everything under the sun, yet there was no findings of finding me unfit. They just had to fabricate or embellish.
Well, and that's where we went to this, is that even mom testified. Here it is, back to the fit presumption. Mom even testified that I had our daughter overnight many nights, and I had her boys overnight many nights, and I was left alone with them through the day because she was at work or she was having to do something, or we just had separate schedules and we were a part of normal life. But those aren't even my children, and I'm being left with them. She also fought against her ex-husband to try to move from this area down to Southeast Texas. And now that she's here, Now she's removing another parent. Now she's attempting to remove another father from the child's life. It's a circle. It's circular for her because it's just the next action in the wheel for what's going to happen. Is that if I can't claim it, which, and Alan, and you can speak to this, but at the end of the day, if your affidavit didn't allege all the things needed to be alleged, meaning that you brought it up in that moment, and you wait until you get to court, it's a retaliatory action. It's not. It should not be taken for this is substantial proof or evidence or finding, because if you were so prominent on that this happened, you would have put it under oath in your original affidavit. You didn't do it.
Yeah.
You only allege it after you feel that you're losing. You could lose the position that you have with the ex parte TRO.
So let's go back to, we need to implement this new constitutional amendment.
Okay.
George, you want to continue on that?
Yeah, I think it's going to take a lot of education. Honestly, we're moving mountains. A lot of us have been in the advocacy for, I'm going on 10 years. I mean, at some point, we have seen the things that we have done. And this was one of the things I advocated for. I cheered for it. I got people to rally behind me to make sure that we start telling parents that ultimately we have the right for care, custody, and control. And because there's some people out there that are, again, embellishing or fabricating, right? And now our rights and our duties, these are our duties and responsibilities, rights, duties, and responsibilities that this constitutional amendment has given us. It's our duty to protect. And while there are people on the other side of this that will say, hey, I'm protecting from Cody because he's taking my child from me, there are fact finders. Those are the judges. The judges are the fact finders. They're the ones who ultimately adjudicate the facts. But when you're trying to give evidence or exhibits to show that there are issues and these judges don't want to find that fact,
right?
When does that cross into official oppression? If we can't remove his Second Amendment, why are we removing Cody's 14th Amendment?
No, that's 100% straight with that. At the end of the day,
so you can exercise your Second Amendment, you just can't exercise your 14th Amendment. That's what we're getting at, right?
And the other side of this too is that it was an inconvenience for mom to be at the grandparents again. They lived there for 2+ years. We lived there for 4 months after the child was born, 6 months after the child was born. And then we moved into this house. She picked up, packed bags, went over there. And now it's an inconvenience for her to be back in her parents' house.
Well, inconvenience does not apply strict scrutiny.
No, it's just like taking a bus. If a judge says, hey, I don't want George taking Christopher on the bus to school because it's an inconvenience, it doesn't matter. It goes back to the Troxel and Granville and the Justice O'Connor saying that just because the judge believes a parenting style or something is better doesn't remove the parental rights and duties and responsibilities that they have to their child. And if that child has to take the bus, if that child has to wake up an hour early, it's not up to that judge. It's up to Cody to decide whether he wants to wake his child up, whether they want to take the bus, they want to take the car, the truck, the work truck. It doesn't matter. As long as Cody is providing a roof, he's fit, he's not abusing the child, there's nothing there that would restrict his rights. Just because of an inconvenience and she has 2 other kids with another man, that Cody should leave his house? Come on. Okay, so when do you got to be out of your house?
Tomorrow or Monday at 7:15.
Woo, man.
That was Thursday to Monday at 7:15. And severe weather. And this day and age, you got to do background checks. You've got to do credit reports. And I've ultimately ran into the biggest hassle trying to rent a house because the house is on my credit. So they don't think that the income's there. So they want to charge you 6 months of whatever.
So wait, when did they tell you had to leave the house?
Thursday.
Today is Saturday. And they want you out when?
Monday by 7:15.
Or what?
They didn't say. I'm assuming there's no order signed yet, but it's verbal. I'm assuming that they will file a motion of contempt if not.
It's got to be written. It's got to be signed. It ain't going to be signed by Monday.
No.
So this happened in Comal County, New Braunfels. Cody totally railroaded, but Cody has seen this before. Cody's a fighter. Cody has seen this with his, he's very experienced. Again, he's seen this with his first court case in Jefferson County. Again,
let's stop for a second. If you obey an order that's not signed, then you're basically voluntarily leaving your house. If you don't obey an order that's not signed, you're stubborn and violent.
Mm-hmm. I bet you anything too. If we post this video, that attorney will say, "Oh, Judge, Cody went on a podcast and talked to Mr. Saldana and Alan Oaf, and those guys are trouble to the judiciary." And something that I heard from Carlson Tucker here the other day is, why should us as Americans be afraid to talk about our judiciary, our state agencies? Why are we automatically assumed as unfit parents, dads, violent individuals when we talk about the judiciary? Why are we alleged to be terrorist incels because we talk about the unfair treatment that happens in our family court? And Carlson Tucker,
you're evil for wanting to own the house that you paid for.
You're right. That's your property.
Or where I built a life with my daughter, because I moved from Southeast Texas 4 hours to be here, and I've been here since February, and this is home. Where else would I go? The place that I put my money in, my hard worked money, and I raised my daughter in.
So Cody, what would you tell other men in New Braunfels in Comal County about what you've experienced in that county with the judicial system?
Just in the short time is that if you don't have enough evidence, you're going to be railroaded as well. If it's a he said, she said, and primarily if you don't have an attorney, a local attorney, this is a local attorney that we're going against that was able to walk into the courtroom and able to get what she needed in a short amount of time. It seems like the ex parte pro se didn't get what they needed on the second, so they waited till the attorney got back and got what they wanted. And what I would also tell fathers is that be prepared to have unsubstantial evidence. If you don't have it and it's word for word, just you against her, you're sitting in my position.
Alan?
I would say bring a different rule book. You know, we kind of sort of started to talk about best interest of the child, and I'm saying best interest of the child doesn't exist. I want to play by my rules, which is fit versus unfit. Yep. If neither one of us are unfit, give us 50-50. That's where we're going. You know?
Well, so now, Alan, I asked the question, if they've laid the predicate by, they didn't have the ex parte affidavit that filed first pro se didn't have assault, family violence, just feelings that she didn't like what I did and took the keys. The second one, which was mirror image, if not the same, and then she got the ex parte because her attorney was involved at that point. And then she gets into court, and that's the first time the judge is hearing about assault or abuse by the father that was never alleged before. How do you fight to sit there and say, Judge, I've filed reports, I've given images, you're going to see the images. Here's my story. Now she's saying that I did something that she is yet to prove that she's done anything other than walk in here today and claim a different story.
So the court is going to say, hey, look, it's a compelling state interest that if there's a welfare issue, we need to protect the child. We need to keep the child safe. Cool. I get that. But you know what else is a compelling state interest? Is upholding the law. When you allow one party to consistently fabricate or embellish particular incidents within your family court proceedings, right? When you allow them to embellish and fabricate and you don't admonish, that's also a compelling state interest. A judge can use every lawful means to enforce the law within their jurisdiction. If that judge has exclusive jurisdiction over that court order or over that court proceeding, and somebody is violating the decorum of the court by lying, by embellishing, by fabricating Not only is that a perversion to the decorum of the court proceeding, right? The lawyer that's carrying that is also violating the decorum of the proceeding. But now it's also a compelling state interest that the judge fix that. That's why all the judicial canons, all the disciplinary rules of professional conduct say that there are rules that lawyers need to abide by. And if lawyers, again, Texas Lawyers Creed, are using these means to harass and to remove Cody from his household by fabricating and embellishing, then I think that's where we start crossing into the criminal side of this. Just because you have attorney-client privilege does not mean you can hide behind that to advance a claim in family court, right? You still have to play within the bounds of the law. And if these attorneys are breaking that, are violating the penal code if I violated the penal code at work, guess who's getting arrested? If Cody violates the penal code at work, he's going to get arrested. Alan, would you say the same for you? Right.
Yep.
So an attorney is not any different. They can still violate the penal code within their profession. Attorney-client privilege only keeps that attorney safe from the things they talk about, but not the things that they do, right? So if they are representing that client, they're violating the decorum of the court. They're violating their lawyer's creed, the disciplinary rules, the judicial canons, right? Where does this cross into official oppression? And
that's the other thing too, George, is that if she knew she was going to talk about assault family violence and ask questions, and she knew mom was going to bring that up as a topic, then wouldn't the lawyer be compelled and required to say, you have to go report this?
Could you do that in a criminal court?
No, because the criminal court would sit there and say real fast in a hurry, you're not bringing this up today. You've not alleged it. You've not reported it. You've not done any of this.
Right. You still have to do discovery. It's not going to.
And that's where the affidavit comes in. That because of what we've seen is that people will get what's the bare threshold that I have to claim to get what I need, and then walk into court, and then it turns into a helium balloon, hot air balloon.
About this before, I said the magic threshold is that the child would be impaired.
Right.
Significant impairment standard. How is this judge significantly impairing that child by removing that child from his caretaker, the psychological parent, the parent that child has been hugged up to when they go to bed, the parent that feeds them, the parent that gives them a bottle. I met with Cody and we ate. I saw his daughter eat. I saw Cody feed his daughter. That child is not being neglected. That child there is no welfare. There was no bruises on that child. That child was happy. The child didn't cry. So now you have removed that child's daddy. What significant impairment is this judge doing to that child? And is that in the best interest of the child?
Right. And it goes back to the 14th Amendment, along with the Troxel, along with a lot of CJCs and everything else, where they say the exact same thing. If they're presumed to be fit and they're caring for the child in the manners necessary, then to remove that
Cody,
parent.
have they found you unfit? They found her to be physical, but they didn't find you unfit.
It was only the fact that I have a short temper, which I would have a short temper with anybody who's sitting there lying.
Okay. Care, custody, and control. So they haven't found you unfit, right? They haven't found that you do not care for your child.
Right.
But they removed your custody from the child.
Yeah, and the ability to care for her daily, which was already in place before any orders.
Now, does that child have a constitutional right to, one, have the judicial system do what's right for them? Yes.
Yes.
Right? We all do. The judge's duty is to uphold the laws and the constitution of that state. That's why they have an oath of office. So this child is looking up to this judge to make the right decision. And this judge is saying, well, you got a brother and sister, a half brother and sister. And because their dad doesn't do anything for them, we're going to take Cody's house. Come on, man. Care, custody, and control, liberty, interest, fundamental. I'm telling everybody, start digging into the 14th Amendment. 14th Amendment is a lot more than just due process. Is a lot more than care, custody, and control. Is a lot more than liberty, interest. Start studying it. Start looking at the case law. We have to remember the best interest statute in the Texas Family Code was embedded in 1995. And it was probably embedded before then, but when they restructured the family code in 1995, that's the stamp it has, and it hasn't been stamped. It hasn't been amended since 1995. Troxel happened in 2002. We are in 2026. How many cases from 1995 to 2026 have we seen where they have, given us more clues, a more definition of what's in the best interest of the child? And why is this judge still using policies and procedures from 1995 in 2026? Those are questions we need to start asking.
Well, and that was her major complaint on the side of it, along with routine and her other boys was, well, it's her young age. This is not an infant.
No, the
tender years is not anymore.
The tender years doctrine has been repealed.
Yeah, and at this juncture, if she has no special requirements or needs medically. She has no reason to be on any type of medicine daily that requires you to be there every beck and call. She does not, obviously still not breastfeeding at any moment. That didn't happen, but maybe a little bit. She's completely independent of anything that other than she can't do for herself.
Okay, so Alan and I talk about this all the time. A lot of fathers, when we go into family court, we're treated equal but separate. So when you had the Civil War, people were fighting, and there's going to be some people fighting, some historian telling me what the Civil War is really about. I don't give a shit. I'm telling you what they've taught me in school. What I've learned was mostly the Civil War was about slavery, keeping everybody equal. We had the 14th Amendment. But then what did we see post-Civil War? We saw where whites had a water fountain and blacks had a water fountain. Whites went to white schools and blacks went to black schools, right? So then there was this case law. And this case law created the equal but separate doctrine, which that's how they treat us in family court. Hey, Cody, you have all the rights and duties and responsibilities, but we're going to give mom sole managing conservatorship, or we're going to give her custody in these temporary hearings. Cody, you're an equal. You're a father. And they're going to tell you that over and over again. And it's an equal but separate doctrine. Now, what came after the equal, or what repealed the equal but separate doctrine?
Was it Plessy versus Ferguson? It
was Plessy versus Ferguson, which got the equal but separate doctrine, right? That's why you had white water fountains and black water fountains. Those were for the people. But then when the Board of Education, what was it?
Brown versus the board.
Yeah, Brown versus the Board of Education comes out. That repealed the equal but separate. Now you have little white girls and black girls going to school, ends the segregation. But when we go to family court, we're treated an equal but separate. And that's something, again, we need to start educating parents about and start telling parents that, hey, look, if we're going to be equals, we're going to be equals. Right? Man or woman, if you're a parent, 50-50 from the start. Unless there's welfare issues, unless you have a woman standing in front of your car making a bitch fit. And I can say that because my ex did the same thing. She kept me from leaving. She would stand in front of the doorway. She put her hands there and say, no, you can't leave. You're going to argue with me. Or she's standing in front of my truck when I'm trying to leave to go to work. Or she's tearing my shirt. Right? And that's something that we need to keep educating with. We need to just keep educating the public about these issues. And I truly think we're moving mountains. But again, if we keep playing the same cards these family law attorneys are playing, we're not going to get anywhere.
No.
We're not.
No, that's what we're looking into. I mean, at this juncture, the judge has done what she's done, and you're right. If I was to walk out of this house on Monday at 7:15 without an order signed, I'm voluntarily leaving. I'm not saying that I'm not. I'm just at this juncture. You've completely stripped me of daily contact with I've only seen my daughter 2 times in the last 20 days, and that was for 9 to 4, so about 9 hours, if you will, 7 hours, and 9 to 6, right, which is about 9 hours. That's it. That's the only contact I've had with her in person, and it talks about that standard from about the ages of born until about 3 years old, where they're the most influenced. They gain the most bond. They know whether somebody's safe, whether somebody's not safe. They gain the attachment, and they also, the more time you're away from them, lose that attachment.
Why are pro se litigants having to teach the state judiciary these findings? Like when I was in the fire department told me our policies and procedures, how we were going to do things. If the laws changed in EMS, they would come out and they would say, hey, look, the laws changed in EMS. This is how we need to do things, right? So why is the public, pro se litigants, saying, hey, look, judge, we have all of this research that says taking a 1-year-old from the psychological parent, from the parent that's been there, the parent that's been holding them and nurturing them, causes harm to this child. Why are these judges continually violating that? And why are pro se litigants that are the citizens that these judges pandered to elect them to that seat? Why are we having to teach them? Why is the judiciary of the state of Texas not educating their judges, their bar, their family law attorneys? That's my question.
Well, I think it's because it's a status quo. You get into a rhythm of it's just another template. It's just another click and plug names in. It's the same story, and if it's not the story we need it to be, we will change it over the course of the case. And that's kind of my statement to it is that so somebody has an aggressive manner, or somebody talks loudly, or somebody's got a military background, or somebody's got a school teacher background, or stay-at-home background, whatever that may be, and it doesn't meet the threshold that they need it to be to absolutely get the results they need, we got to get it to here. How do we get it there? We start bulking and exaggerating every claim that we can. And we no longer are trying the facts. We're trying the feelings. We're trying, to meet what the judge is going to be readily identifiable to say, I can do this. Right. So if that judge strictly did it in the criminal mindset, that judge would have sat right there and said, I'm not listening to this. Is it alleged already? Is it already in your petition? It's not. So now you're going to go back and claim it after it's already been claimed on the other side? That absolutely is not going to fly here. You're not going to do this.
Right. Ignorance to the law. Ignorance to the law is not an excuse. So a judge, again, where does a judge cross that threshold for official oppression? Right. Well,
until you make, to Alan's credit, until it's argued, until it's ruled upon, you can't put that threshold on paper. I mean, I'm just talking about simply that. No different than your training in the fire department. They have no idea whether George can do X, Y, and Z until it's applied. So we have no idea what that threshold is until it's applied and it's upheld.
I will tell you that I'm
going to repeat something that George said. Cody, it's your job to teach that judge about the Constitution.
Yep.
So you may have lost the battle, but at final trial, you're going to be able to educate them about the law. And you're going to be able to educate the judge about this new constitutional amendment and how it applies to Troxel versus Granville. So that judge is fortunate to have you in their chambers.
What do you say to a judge that says, I don't want to hear from you about the Constitution or the laws
dismisses
of the state?
It, right? Because if you file anything of in any type of anything before said actions happen. Psychological
Isn't that part of
evaluation
due
has
process, the right to be heard, and a judge is telling you, Cody, I don't care. You didn't go to law school. Don't bring that argument into my court. I mean, is that official oppression? When a judge tells you, no, I don't want to hear you, when you have a right to be heard. If you have a right to carry your sidearm and someone comes and takes Cody's sidearm,
you have the right to petition your government.
Right. Redress.
Absolutely.
Right.
You have a right to go and speak to them. You have a right to question them. You have a right to speak out about them.
But your judge is saying, no, zip it, Mr. Saldana, until I acknowledge you.
I've got a roll of duct tape. Have we heard that?
How is that not a failure of your due process rights? You know?
I mean, it is.
Right. These judges are doing that.
It's the bare. See, this is my thing, and y'all can probably agree with this to an extent. Is that it should be a bare, basic, just platform that everybody sits on. It should not be, well, I'm going to wait until I feel like you've met that platform. No, it should be the platform at which we all walk into. Is that the criminal side is you're innocent until proven guilty. It's completely flipped when you go to the family court.
All right,
you're
guys,
not innocent until you prove it.
All right, closing this thing up. Some of y'all heard some of the things that happened in Comal County in New Braunfels, Texas, from Cody. We've seen these tactics. We've educated ourselves. We're trying to educate you. I was hoping that y'all were able to take something from this little get together we had. Tell us what you think in the comments. Cody, as we wrap up, what would you like to say?
It doesn't matter where we're at. I still am appalled that you can be a fit father. You cannot be found to have committed any harm against your child, and yet you still walk away not having or being around your child. Loving your child's not enough. So now it's to the point where you have to dig in. You have to be willing to fight. You have to be willing to go to all ends for the child, or you will be sitting there going, 18 years passed me by. I've given up a lot of money, but I've given up a lot of time that I'll never get back. And that ultimately for me is the 17 years that I'm not willing to just walk away from.
And you're a girl dad, right?
I'm a girl dad, man. I don't want anything more. I used to want a boy, and now there couldn't have been anything better.
I'm a girl dad.
Alan
as well.
knows that.
Alan, you a girl dad?
Yeah.
Yeah, we're all girl dads. Okay, Alan, wrap it up.
Well, so in light of everything that I've learned about Cody's new circumstances, I can't recommend it to him as legal advice, but if I were him, I would do three things. I would go around the DA's office, not ask for assistance, but file my own petition myself for an application for protective order. I would use the fit parent presumption in court and argue that they haven't shown strict scrutiny.
Ordinarily tailored.
And third, I would file a constitutional challenge and preserve all of this on the record in trial to get ready for an appeal, to basically reverse the laws in Texas through the courts rather than through the legislation.
Well, there you have it. I would say, Cody, I know you invited me to go in court observe for you. I haven't had the opportunity, been sick, had some vehicle problems, but those have been overcome. So I do anticipate going to watch your judicial proceedings moving forward. But I think you need to take court observers. I think a lot of us need to take court observers to not only document the things that happen, but we're going to need to start educating more people about the things that happen in these courts. When we go by ourselves, when we don't document, we're just shooting from the hip like we are doing now. You don't get a lot done. So I would suggest that moving forward, that you definitely take people with you. Never go to family court alone. I know Cody knows that. Alan knows that. But other than that, Cody, thank you for telling us your story. I know a lot of people are somewhat hesitant sometimes about telling their story because they know retaliation's coming. But usually if they're retaliating when you're trying to talk about the injustices in family court, that's a big no-no as well. And we need to highlight that. So any attorney that's watching this that says, oh God, these guys are talking about their case online. again, I think we're seeing attorneys starting to use more constitutional arguments in their cases because they have been seeing what a lot of us advocates have been putting out there. So thank you guys for helping us push the mountain a little bit, or adjust the scales accordingly, I would say, because without us, it's a no-win situation.
How would you know?
Yeah. So, hey guys, thanks for coming on, and I'll get this out. Thanks for watching. Later.
All right, thank you.
Later.